a sign-in sheet, so if you're here, just initial it. There is a seating chart, and so that will make its way slowly around the room. Make sure you put yourself in the seat that you plan to stay in for the semester. If you move next class, make sure you update the seating chart. There are index cards going around the room, and there is a copy of the syllabus going around the room, and it should get to everybody. Everything should get to everybody, but if something gets clogged up, there's more than enough copies, just wave down your classmates if you're not getting any of those items. The seating chart will probably take the longest to get around. So with the index cards, I'd like you to put down 3 pieces of information. Put down your name with a phonetic pronunciation if it would be helpful. Like my dad's last name is Zale. For both your first name and your last name. My last name is Zale. Sometimes people say Zale, but I'm like, no, Zale, like kale. So like put down a phonetic pronunciation, whatever makes sense. Put down, what else do I want on that piece of paper? Your name, the phonetic pronunciation, and it's on the PowerPoint, so we'll have to look on the PowerPoint what the other item is. Okay. There's extras, yeah, you can just leave those. It's open. Name, where you're from, and one non-related law fact, non-law related fact, so not a law fact, don't tell me something about the law. Something about yourself that's not related to the law. And you don't have to turn those in like now, we'll just collect those at the end of class, we'll pass them to the end of your row quietly during class. We'll talk more about that in a moment. So what we're going to do today is I'm going to talk a little more than I normally do for the first part of class, because we're going to review the syllabus and class policies and just big picture overview of property law, what the expectations are for this class. And then we'll take like the next 20 minutes or so, and then we'll get into the assigned reading for today. So there were 2 cases assigned for today. And we'll get into that, and that will be more like the normal class procedure. So with regard to the beginning of the syllabus, the class policy, so I passed around a printed out copy to everyone, but it's also up here on Blackboard under syllabus tab. The same copy is there. And so if you want to look at it electronically, you can do that. But we're just going to kind of, again, most of it's pretty self-explanatory, but we're going to go through just the basics to make sure everybody is clear on the policies and the kind of expectations for the class. And so, oh, it's not showing. Let me show. Now is it showing? Yeah, remind me. Sometimes that button, I just remember to press it. All right, so I am Professor Zale. I teach first year property as well as upper class real estate, land use, local government classes. And I used to be a real estate attorney, and so property was my favorite first year course, and so I know it will be everybody's favorite first year course, but I really loved it, and so I hope that I can get some of you to, if not love it passionately as I did, at least like it. And so we're going to be going through, you know, I'm not going to read aloud the objectives and the learning objectives there, but that's the general goal for the course. The required reading, there's 2 required books, and so there's the required case book, which will be most of our semester will be spent on materials in this. There's also a required workbook, which we'll be using for about a week and a half in the middle of the semester for a specific set of materials called System of Estates and Land. And so both of those books are also on reserve at the library. I don't think they're on reserve yet, but they should be as of this afternoon. And so if there's a day where you forget a book or you need to catch up on the reading and you don't have your book, you can use those books that are on reserve. As you see, there's also a third category, required reading, required supplemental reading. There's not often supplemental reading, but if you look on Blackboard again, There's something called required supplemental reading tab, and there's just a few items on there. And you'll see when we get to the schedule of assignments where those items fit in. They're assigned on specific days where they fit in with the rest of the reading. And so there's a few days where you'll need to also go there and take a look at that material as part of the reading. Because students are responsible for all assignments that are listed on the schedule, whether they are in whichever of these two textbooks or in the required supplemental reading. The schedule, so again, first year classes are always a little odd. They meet at different times on different days. So we are on Tuesdays and Thursdays at this time, and then tomorrow on Wednesdays in the afternoon. And the way that first year classes work is also the amount of time that the school schedules overschedules the amount of hours that the ABA requires. So all the first year property professors, we get together, we do the math, and we realize we can cancel 5 classes by holding class till the 50 mark at the end of class rather than letting you out at the 40 mark. And so we hold a class for that amount of time, and therefore we are able to cancel, and you can take a look at the schedule on the later pages to see which classes have been canceled in advance, but 5 classes have been canceled in advance. Starting, unfortunately, with my jury duty next week. So hopefully that will not get more long. The other ones that you'll see are canceled for, they'll say no class, and it's because I have conferences. And then there's a few that say makeup class if needed, otherwise no class. So those are part of the 5, but I've listed them that way because I'm keeping them as buffer classes, because in case, hey, I actually get put on a jury, or I get sick, or there's other unforeseen circumstances, then we already have buffers built in. And if I got put on some terrible jury that needed me for weeks and weeks, then any additional classes would be assigned, subject to the school's makeup policy, but I really hope that's not necessary and don't expect it will be. But you'll see this means that we'll get to end the semester early, and there's will also be ending earlier before spring break as well. And so these classes are, again, built into the assignment schedule. Office hours, I'm just going through the syllabus in the order that it's listed here. Office hours, they're on Wednesdays directly after this class. That's a time that was blocked as free during your schedule. I looked at the section schedule, and so that was a free time, which is why it was chosen. But if that's a time that you can't meet and you want to meet, I'm available to meet at other times. I'm just not regularly, consistently in my office at other times, so you have to just email me to schedule a time to meet at another time. The course website, again, Blackboard here, this is the course website. This will be where announcements are posted. This is where, in addition to the required supplemental reading, some days we will have handouts or worksheets in class, and that's where they will be posted under this handouts tab. There might be a few left over from the previous year on here, but I'll clear them out and put this semester's on. This is where the class PowerPoints will be posted, and other miscellaneous items will be on Blackboard. So make sure that you have access to the class Blackboard site. And when I send group emails, I send them through like the Blackboard application. So whatever email address Blackboard has for you is where it goes. So make sure that your settings, and again, that's not something I can do, but your settings on Blackboard is the email, like it's either getting forwarded to the email you check, or that is the email you check, because all of the announcements, like there is a makeup day, or if we do have to adjust the reading, the announcements go through Blackboard's email application. The classes are automatically video recorded, and so this is the website where you can access them. It's not usually immediately the second after class ends, it's the UH system, but usually fairly quickly after the class has been done in real time, there is a recorded link available. And they stay up all semester, so if you miss a day, if there was a day later in the semester you want to go back to, because you were like, I was really confused that day, I'd actually like to watch that on like speed and a half time, you can do that. And so that's made available to all students. There's information here about the assessment method. We'll obviously talk more about this later in the semester, but I put it out here because I just want to be upfront with students ahead of time. The way this class's exam works is every first year class is different. It's a 3-hour in-class, limited open book final exam. It is 50% multiple choice, 50% essay questions. Limited open book is explained there. I'm not going to go into details on that. I'll go into details on that later in the semester, but for your information, that's what that means. And there will also, to aid students in exam preparation, there will be a mandatory but ungraded mid-semester assessment. So this will be before spring break at the end of February. Thank you. It'll be a 1-hour take-home, one essay exam question. And you'll have like a 3 or 4 day window to like download it and upload it through the school's software. And then after spring break, you'll see on the schedule, there's a part of a day after spring break that's devoted to reviewing the mid-semester assessment. And you'll also have an opportunity for one-on-one brief review sessions to go over yours with the teaching assistants who will be working with me on grading, again, grading in quotes, the mid-semester assessment. And so that's a useful way to get some practice on essay questions. And then in addition, each week I post on Blackboard an actual past multiple choice question from a past exam. And so there's a tab on Blackboard that will become activated next week that will have weekly past multiple choice questions. And again, they stay up all semester, so you can do them each week, or you kind of save them up and do them as a bundle, but they correlate to the week's material from the previous week. So they are also a good way just to check your understanding each week, as well as being an exam practice mechanism. Moving on, class participation. You are second semester students, so you have at least one semester. You kind of know how law school works at this point. Classes are a mix of lecture and discussion. Students are expected to be prepared for every class, which again includes all of the assigned material. And this case book in particular will have primary cases each class, most classes. But a lot of the materials in the notes and the problems in the case book, so make sure that you read those just as thoroughly. We utilize the on-call system. I'll be using those cards not just to get to like put names to faces, but also as a way that I keep a matrix and I kind of shuffle them, and then use those as a way to call on students for the day. And so several students, multiple students will be called on every day. And if I call on you, for the facts of the case, and then maybe to one of your classmates for like the reasoning of the case, and then somebody else for the problem of the case, I still might come back to you that day. So don't kind of tune out just because you spoke for like 3 minutes at the beginning of the class. So all students will be called on several times during the semester. Again, I keep a matrix, and so I keep a record of students' on-call participation, so that it is even over the semester. There is a pass system, however. So if you have a day where you just are like, I can't do it today, I want to be in class, but I just had a lot going on yesterday, I can't, I read the material, or maybe I didn't read the material, but I'm just not prepared to be on call. You may utilize a pass up to 3 times over the course of the semester. So this explains how you do it. You have to write your name and a date on a piece of paper, and I don't supply them, so you have to have a piece of paper, and leave it here at the podium before the start of class where I can clearly see it. And so if you do that, you don't need to write an explanation, you don't need to say why you're doing it, just leave it there, make sure I can see it. I will mark you on the matrix as passed, it won't count against you as long as you do it 1, 2, 3 times. If you do it more than 3 times, it does count against your class participation grade. The attendance, again, you saw this will be passed around. Each class, just sign your name in. And again, there's excessive absences also potentially count against class participation. Latenesses can be distracting to me and to your fellow classmates. And again, I know that life sometimes happens and you might actually have a legitimate reason why you're late. If you're late, please be very quiet, walk in, try not to disturb me or your classmates. And unless you have permission from me, either that you got before class because you emailed me about like a known lateness coming up, or a known early departure, or that you come speak to me after class, you can't sign the sign-in sheet unless you're here for the entire class. Again, unless you've gotten permission from me. Technology, so laptops, computers are permitted for note-taking purposes. And again, violations of this policy will be counted against the class participation portion of the grade. All other devices should be turned off in silent mode and not be used during class. Information about accommodations and the discrimination and sexual misconduct policy are there. I'm not going to read those aloud, but please take a look at those. And then the course structure, so the last 2 pages of the syllabus kind of go with the day-by-day course structure. So a couple of notes about this. I have set out the reading for the entire course, but when I've taught this class in the past 2 years, it has been a twice-a-week class, like 2 hours twice a week. So now doing it for 3 days, for an hour and 20 minutes, or whatever it divides up into, for 3 days a week, I had to make some guesstimates, like how would 2 classes worth of reading fit into 3 classes. I think my guesstimates are pretty accurate, but again, there's an underlying thing here that the schedule below is subject to adjustment. If like my guesstimates have been wrong and it turns out the pace of class isn't quite, like I messed up like how 2 classes would translate into 3 classes of reading, I would let you know, obviously, and I would post a new updated syllabus on Blackboard. And so this is not set in stone, absolutely, even though I have tried to make my best guesstimates for the schedule. Another item is that, again, this happens even when I teach the exact same scheduled class from one semester to another, just the paces of different classes move differently. So there will definitely be some days where we have a little bit of material left over from a previous class. Again, the syllabus kind of puts this in bold. All students should be prepared to discuss that leftover material at the start of next class. And so if that's like happens on a Tuesday, and the next day is a Wednesday, that's pretty easy, because you're like, I just read that the day before. If that happens on a Thursday, the next class is on a Tuesday, you need to refresh your memory, because most people kind of forget the details and get a little fuzzy about what was left over, because we will start with it on Tuesday's class. And all students are expected to be prepared to continue to discuss the material. The last bit of advice or information here is that, again, as I mentioned, a lot of the material in the casebook, in addition to cases, has some problems and notes. You don't need to write out your answers. If that helps you as you take notes, you can do that, but you don't need to write out your answers. When we get to this material, it's a workbook, it's problems. You do need to write out your answers. I won't collect them, but class discussion will not be productive unless people write out their answers. It's something you can't do on the fly as you're thinking there. These are, as you'll see when we get to it, they're not like the rest of property law. And so you will need to write out your answers when those are assigned. And so then again, this gives you the schedule, the abbreviations for what is what, and I think everything else is pretty self-explanatory in the last 2 pages. So just questions about logistics before we get into the assigned material. So there are, again, I usually have PowerPoints for every class, and I try to post them. So if you look on Blackboard, there's a tab called PowerPoints, and I try to post them like each week. So I try to, so that students like the Monday night, if they want to print out the set of PowerPoints for the week, they can. So they're not posted for the entire semester, but they should be there each Monday night. There should be that week's set of PowerPoints. I can't promise, because there's some weeks where just crazy things go on, and I'm doing them the night before each class, but usually they're there each Monday night. So we are in this first set of PowerPoints. We've gotten past that. So again, I'll have a chance when I look at your cards, maybe, and I'll have a chance when we talk more over the course of the semester. But these are just some informal, like, not going to remember even who raises their hand, but informal questions. Who here owns where they live, like owns their residence? Okay. Who here rents where they live? Who here is other, like maybe lives with parents or like some other situation? Okay. And who here has ever entered into a lease as a tenant? Like ever in your life, ever. Who here has ever entered into a lease as the landlord? Okay, a couple people. Who here has ever bought a property, whether it's your residence or any property that's a real property, not like a computer, like a real estate? Okay, a couple people. Who here has ever sold real estate, like that you owned? Okay. And I won't answer the other obvious question. Who here has bought something? All of you have bought property or sold property at some point, probably. So we're kind of just, again, doing that because a lot of property law is, like some other areas of first year law, particularly contract law, it's something you're already doing in your life. It is something you have in your life, but you probably haven't really thought about it very much from a legal perspective. Again, with the exception of maybe the times that you're signing a lease, the time that you are, closing on a house that you're purchasing, something like that. But it is something that you are engaged in as part of your life, and we're going to kind of like really dig into like the why and the what and the how of things that you've probably been doing and not really thinking about from that perspective. So we often think about, you have, I think this is yours. Yes, okay, that's yours. And so you think it's yours, and you think that means when you say that's like my backpack, that means, what does that mean to you? Like, what does that mean when you say it's like your property? Like, what do you think your rights are?
That I can decide what to do with it.
Okay, and what might some of those decisions be?
If I want to hold on to it or get rid of it or destroy it.
And so like, she has that backpack, and so from your perspective, saying that it's hers, not yours, like what do you think your rights or obligations are with regard to her backpack?
I wouldn't think I have any rights.
So you might think I have like no rights with regard to somebody else's property. And that is an intuitive and in many cases mostly correct assumption, but we're going to see actually that sometimes non-owners actually do have rights with regard to other people's property and their ability to access it. So we'll talk about how, in emergencies, you can actually go onto somebody else's property. That for certain public policy reasons, we allow certain government workers, like, emergency providers or social service providers, to go onto other people's property. And even if that person says no, there may be an exception that allows them to go onto their property. And we'll see how even, say you have this, let's make it not a backpack, let's say you own an apartment that you are a landlord of. So just now transform a backpack into an apartment. So you have that piece of property. So would your sense of your rights and ability of what you can do, because you're like, I can do basically anything with this. Do you think you can do basically anything with that apartment?
If I have a tenant, I think it's limited to whatever the laws are.
Good. So you have a sense that, if there's somebody else with some property rights in that apartment, then maybe my property rights as the owner, because the tenant must have some kind of property rights with that apartment, you have a sense, that it's not as absolute. And maybe it's not even as absolute without the tenant. You might think, what if you wanted to just demolish your apartment? Do you think you could just do that?
No, because I don't own the building, so apartment.
So one might be you don't own the building. Yeah, I didn't clarify like whether you own just the apartment standalone or the building. So one might be there might be other neighboring owners or tenants that you have responsibilities to, neighbors. And even if you did own the whole building, do you think you could just go out one day and demolish it?
No, because if I wanted to demolish it, I'd have to get like approval.
From some government agency most likely. Again, we're going to think about like you doing whatever you want with your property would affect what your neighbor wants to do with their property. So we actually don't allow people generally just to do whatever they want with their property. There's a whole set of land use regulations and zoning regulations and things like getting a permit for demolition. And so we'll get into a lot of these topics over the course of the semester, but I kind of want to bring them up now at this point just because, again, when we're thinking intuitively about property, we tend to have this like absolutist vision. It's mine, I can do whatever I want. And really, if you step back, and this is what the law does, it steps back and it thinks more big picture, property really is about balancing rights and responsibilities. And yes, the owner is going to get a certain, we'll see this phrase next class, bundle of rights with their property, but the scope of those rights and how we balance those rights with non-owners or other owners or society at large will vary with both the type of property as well as with it kind of as society changes. The rules that were present in England, although you will soon learn we still have some of those rules back in like the 1500s, aren't necessarily the same rules that we have today. And I say all that, this is again some of the things that we will talk about over the course of the semester. We don't need to come to that for now. I say all that because a lot of the early cases that we cover in property are old cases. And particularly when compared probably to your contracts class, and maybe even to your torts class, which might, have more modern cases, at least to start with, or you're not like reading all of these old cases kind of right away. Students sometimes are a little bummed out by like all the really old cases in property and like, why is this relevant? So we're going to try to work through why this is relevant. But property law is and I say this not in like a political way, just a conservative area of law, meaning slow moving, slow changing area of law. And we'll talk about why that is and about, the need for stability and certainty in this particular area of law, therefore the slow movingness, the conservativeness of change. But that is part of the explanation for why we are starting with several fairly old cases, but why they, as we'll see, are still relevant even though, we're not doing a lot of litigation over Native American conquest or, fleeing foxes anymore. But the concepts from these cases are still actually relevant today. So let's get started with the two cases that we do have for today. So because I don't have the seating chart, because today's the first day of class, I'm just going to kind of point at people. And it's also if you decide you need to pass today, it won't count against you just because today is the first day and I'm feeling generous. It's the new year. I'd rather you didn't pass. I'd rather you try today. Today is the only day that's the case. So I'd rather you try because it won't count against you if you're just struggling either. But I apologize, I'm just going to have to point because I don't have the seating chart yet and I don't have the cards and haven't gotten everybody's name yet. So the first case is this Johnson versus McIntosh case, and it is one of the few, just before we get into the facts of the case, it's one of the few, what page is it on? It's page something. Table of contents. It's one of the few Supreme Court cases we'll actually have. In property law, we don't cover a lot of Supreme Court cases because most of property law, again, like torts and contracts, is a matter of state law. So most of our cases will be state cases, but there will be sprinkled kind of throughout the semester a few U.S. federal Supreme Court cases. But it is not, don't get all excited that this is like, ooh, it's our first case, Supreme Court case. All the cases will be Supreme Court cases. They won't. They will be, for the most part, state law cases. All right, so I'm going to just have to point. I'm going to point to the California Republic person. Okay. You can tell me your name when you speak.
My name is Sean Norquadra.
All right, Sean. Do you want to tell us who the relevant parties here are?
Sure. So we have the plaintiff is Johnson, who's claiming that he received this land in question from buying it from two Indian tribes.
Yeah. So he's the plaintiff, and he says that he has purchased a parcel of land from two Indian tribes. And who is the defendant? What is he claiming?
He's claiming that he bought it from the U.S. government.
Good. So they're claiming they both own the same piece of land. Good. So they refer to in the case many times, legal title or title. Did you get a sense, they don't ever define it clearly for us, the justices in the case. Did you get a sense of what do you think legal title is?
It's probably, I interpret it as the right to the specific tract of land.
And the right, when you say that word right, can you make that a little more specific? Like,
The right to own and defend your ownership of land.
yeah, so the legal ownership rights, whatever those are, we might say they're the right to defend, the right to sell, the right to use, the right to, we'll get more into like what those bundle of rights are, but it's the legal ownership of the land, that's the title to the land. And we'll talk later in the semester more about kind of the chain of title, like the chain of legal ownership, but here you have two competing chains, and so, chains of title. And so you have these two, the plaintiff and the defendant, and they are both claiming they have title, legal ownership to land, but they're claiming it through two different chains of title. So, the question for the court is, who owns the land, but it's a bigger question, John, like what do they have to figure out, or what does the court kind of go through to figure out who owns the land? Like what's their question here?
I think they used like the chain of ownership sort of theory where they kind of trace back who owned the land prior to the person giving you the title. And they found that the U.S. government was their common owner. But even though the plaintiff's ownership went beyond that to the Native American tribes, the court still ruled that the U.S. government given title was the one that wins.
Yeah, and so in here, there's like a little bubble, it's not like on here because it was going to be confusing, but note 3 talks about it. The U.S. government did enter into a treaty at one point with the tribes, and so like there is a bubble here, you can put U.S. government also involved on this side. But the court is looking primarily at the U.S. government as the kind of the previous title owner here and then tracing it backwards as Sean said. So, we got to the kind of the end point, correct? I'm going to ask your neighbor with brown shirt, gray shirt. What's your name?
Stephanie.
Stephanie, okay. So Stephanie, so what were some of the arguments that, let's start with the losing side. The party, the plaintiff who got their title from the Native Americans directly, what was kind of their legal argument about why they think they should win?
Johnson thought he should win because he was given the land by the Native American tribes who rightfully owned that land.
Yeah, so he says, hey, these groups, they were there and they owned the land and they had the right to convey it to somebody else. And so why so the defendant has to rebut that, and they're going to rebut it with their chain of title, but they're also going to just, in thinking about that chain of title, like why the Native Americans didn't have ownership, like why this chain of title, this group of people did. So there's a couple different arguments, but what are some of the arguments as to why the Native Americans did not actually have the ownership they thought they might have had?
I saw one argument that the reason, what they were using the land for wasn't considered ownership to American law, so they thought that they were the ones that actually owned the land and that they had the title to give to the defendant.
So, yeah, what were the Native American tribes using the land?
They said that they were using it for purposes that weren't considered ownership. Cultivating the land and stuff. Considered ownership under American law.
So good. So, you all know from your U.S. history courses, Native Americans tended to use the land in different ways as more, they were moving around. They were not cultivating patches like the European settlers who came over and created their, various farming areas and cultivation of land. And so you see this kind of commentary in the case saying, well, one of the things that to us signifies ownership is using the land in this productive way, like the Europeans were using it, farming it. And those Native American tribes, well, they weren't doing it that way. They didn't act like owners would. So that's one kind of string in the case about why, or one thread in the case about why the alleged ownership here wasn't the kind of ownership that we're looking for. Jean's jacket, yes?
Jessie.
What's your name?
Jessie Manson.
Okay, Jessie. So what else did you pick up in the case about
back and said that in Europe there was this idea that if a specific nation discovered a land that was previously unknown, and I'm guessing they mean by Europeans, then that country, not the discoverer, but the country that sent the person that discovered the land would gain a sort of right. And at some point they said only they have the right to buy the land unless they conquered. And they believe that because of the nature of, they consider the Native American savages, and they're like, they can't own land, they're not people like us. So they decided that their rights were less. But it goes back to the fact that at some point someone from England discovered it, and then the US is the successor of England.
Yes, very good. So there it says, as you point out, this discovery doctrine that the court goes through, and it says all nations, meaning again all European Western nations, agree on this discovery doctrine, that the discoverer's country is the one that gets title to the land. And even if there are people on that land, when they discover it, this discovery doctrine that we all agree on, again, we being like the European nations, the Western nations, that we all agree on, we all know that that means that that nation exclusively has the right to bargain, essentially, with the occupants of the land. And it refers to them as occupants or possessors of the land, not as owners. So even the language that the court uses when it's talking about the Native American tribes, and kind of their relationship with the people that discovered the land. Because the court, as it's talking about the discovery doctrine, it seems to recognize that there's some potential, I don't know if I want to use this word, but unfairness, or it has some discomfort with its discussion. You can sense in the case at different points that the court maybe actually does, and the notes talk about this, how one of the justices, recognized that he felt this was a somewhat unfair case to the Native American tribes. Why do you think there was this sense of maybe unease, even though the court comes to the decision it comes to, unease about saying this is the legitimate chain of title, not this?
Because the discovery doctrine is the very beginning of the chain that led to the U.S. and then the defendant owning the land. It supposes that the mere discovery that, because I found this here, it is now mine, and I have rights to it, and it makes the Native Americans' rights be smaller in comparison to the Europeans.
Yeah, and so that middle sentence that you said, it kind of is based on this, I found this here first. I, the discoverer from England, found this here first. It seems to kind of elide over, like, well, no, first was somebody who was there. There was a group of people that was there first, and they didn't discover it first, in the way that you're defining discovery in court, but they were there first. And there's this sense of, if you're thinking about just logically first, most of us tend to think of first, like, who was there first? Like, if you just look at this logically, the Native Americans were there first. The court even concedes that. But the court has to kind of work around that and say, well, when we're thinking about ownership, that's not all that matters. Like, just being there first isn't all that matters. You have to do certain things that we think matter. You have to do those things first. And then we'll start talking about property ownership. But you Native American tribes weren't doing those things first. You were just, again, we're coming back to Samantha's comment, you were just, being on the land. You weren't using it in the way that we think about using the land. So it goes through some of these concerns. It also has a concern, the court, and I should have highlighted this, it has a concern about has a concern about the kind of, so this case is in 1823. So the U.S. is a fairly youthful nation at that point, teenager, early nation. And there is a sense in the case that the court is concerned about its own legitimacy and not rocking the boat too much and this like uncertain project of the US. And so at one point, this is what I can't find if somebody has it highlighted, it says, you know, the courts of the conqueror are limited in what they can do. Does anybody have that highlighted? Yes, where is that?
It's on page 7 in the fourth full paragraph.
Fourth full paragraph, 1, 2, 3, 4. Yeah, thank you. In that fourth full paragraph, that second or third and fourth line. Conquest gives a title which the courts of the conqueror cannot deny, et cetera, et cetera. So since you found it for me, yes, Shannon. So why do you think the courts, well, one, do you agree with that sentence? Where do you think the courts are coming from with that sentence? Like what's its underlying concern there?
I think the court is concerned with kind of its position in terms of the branches of the government. Not going against the other branches of the government too much so that it will be seen as a legitimate co-equal branch of the government. So if the other branches have taken this action to convey title, then the court needs to respect those branches and not assert its own opinion about how the title should have been.
And so, and this is useful because what classes are you, y'all, I should have remembered your schedule. What are your other classes this semester?
Con law, statutory interpretation.
Okay.
Tell us that's again, and criminal law.
Criminal law. Okay, so you've taken contracts, that's good, okay. So you'll talk a lot about branches of government in your con law, probably your statutory interpretation class. And that's a useful way to kind of start thinking about this. Who do you think the title comes from? Like the title that the court is adjudicating here? Like, is that something that the legislature or executive gives to people? How do you get a title?
I would think that it would come, if it's coming from a treaty, I think treaties are signed by the Congress.
So treaties, right? Why did you say the word treaties?
Because there was a treaty at the end of the Revolutionary War, which passed the title from England and the colonies to the United States.
Yeah, so good. So the court, when it's talking about this discovery doctrine that we all agree on, you know, all of us nations agree on, it's referring to something that was approved by the junior new U.S. Congress at some point early on. And so even though that treaty wasn't necessarily directly talking about the title, like that's what we're searching back to kind of work through the logic of who has the rightful title here. And so the court, kind of in this sentence and in a few other places in the decision, you know, has this concern about, hey, like, it's our job to interpret what the other branches have done. We're a co-equal branch here. And it's not our job to say, like, yes, we personally disagree and think this is unfair, but why else do you think, and it comes up at a few different points in the case, so one is this concern about the legitimacy of the court as a branch of the government, and that the U.S. is just this new nation, and we don't want to kind of rock the boat and say, oh, one branch is like, tell the other branch, don't do this. Why else do you think the court would feel it is not, like again, the sentence, like it is not for the courts to undo the decisions of the conqueror? What other, like, thinking about the conqueror more broadly, not just as the branches of government, but as like the nation as a society and the decisions that nation has made as a society?
I would think it would cause problems if the society had, for example, fought a war and then the courts undid the results of that war. That would cause a major societal problem.
And so, and I want to make sure we're clear, which war would this decision potentially undo the results of?
So this is potentially about the Revolutionary War, is my understanding of the transfer of the lands.
The transfer of the lands, okay. So think more broadly towards like these people are claiming through the Native American tribes, pretty directly, there was a U.S. treaty in there, but pretty directly. These people are just claiming through like the doctrine of conquest and discovery. Conquest of the Native American tribes. What other wars were going on?
You know, some of the French and Indian Wars,
Yeah, and wars used more broadly, just Native American U.S. disputes, U.S. settler disputes, and previous to the U.S. settler, the other like European settler disputes. And so there's this concern also about, if we, the courts, were to tell people like all of their deeds that they thought they got from kind of this side of the line are no good, and really it's these ones over here on this side of the line that are the good deeds, that upsets a lot of expectations in terms of like, we thought we fought this war against this Native American war, again, not maybe dispute, against this Native American group, and we conquered them, and therefore we extinguished their title. We don't have to worry about that. And a decision that came, if the decision had been the opposite of this decision, that would have upset expectations. And you probably talked about in your classes last semester why courts don't overrule, and again, we don't have any direct precedent here, courts aren't citing cases in this case, but why courts don't overrule precedent or kind of previous expectations or reliance. Like, why don't courts, separate like from the Native American and the historical context here, just as a general matter, why are courts fairly reluctant to do that? Just from your knowledge of other classes.
Because it changes people's expectations of, like, for example, in contracts, it's are constantly changing what a contract means, and it makes it really hard for people to know what their contract means when they enter into it, and it discourages people from forming contracts.
Yeah, very good. And so translate that into property law. Why would that be a problem in property law too?
So it would make it harder for people to, or less likely for people to buy and sell property, and make sure that their title is good, or that the title they're seeking to obtain is a good title.
Yeah, very good. This idea, and property law is another area like contracts where we really want certainty because we want these market transactions occurring. And if we suddenly have a ruling that changes like the right line of title that people have ownership, claim ownership from, that wouldn't just affect Johnson and McIntosh. That would affect, I don't know how many, but like a myriad of titles at this time in the United States, and cause a great deal of uncertainty. Again, in a fairly young nation that has, just come out of some wars and probably going into other wars. It's this very fragile country at this point, relatively. So you had mentioned that, again, we talked about how this is one of the few Supreme Court cases we'll talk about. And so you took civil procedure last semester, right? Yeah, that must have been on the list. Okay. So why do, let's see, glasses? Yes. Okay. Sorry. What's your name? Trent. Okay. Why do court cases get to federal court as opposed to state court?
There's like maybe potential unfairness in state court or diversity case or federal question.
Okay, yeah, so big ones are federal question or diversity case. And these people are fighting over the same land, so as far as we know, they're members of the same state. This was not a diversity case. Was there a federal question here? Like, what was the federal law? I mean, unless there's some other way for it to get to court, that has to be it.
I believe it probably would have been over the treatise who actually owned the land.
Over the treaties, you mean, like the ones that were signed by, the Congress at some point. So, does the court though ever cite language from the treaties? Yeah, so the court, even though it's referencing treaties as part of like tracing the chain of title, it doesn't seem like this is like something like where courts like interpreting NAFTA or some like international law treaty. Like that would clearly be a federal court case that would go into federal courts because it's about a treaty. Treaties are mentioned here, but treaties don't seem to be the thing that the court is necessarily like the reason this got into federal court. Does anybody have any thoughts on like why else this might be in federal court? Like normally, again, property law cases go to state courts.
Like the legitimacy of the American government possessing the land?
Yeah, so that's again what we've been talking about, exactly good. But like again, if you're thinking about civil procedure, like how did this get into the federal court system? Like I can't just go to the courts and be like, well, overall my case is about the legitimacy of the US government. Let us into federal court. Like
But with like foreign relations. Because if the other foreign countries got the lands from the Native Americans, they're just making transactions with Native Americans. It seems to like bypass the American.
Yeah, very good. And so there's this is about foreign relations in some way, foreign relations both with regard to all the discovering, conquesting nations and their chain of title, as well as like Native American tribes have a special place in U.S. law. There's a whole area of law called federal Indian law about that. And they are not treated as foreign nations, but they have this very interesting quasi kind of special place. Not always special in a good way, but special in a unique way. And so the sense that this is about international law and that it is not, it's the entry point into the, and again, I don't have the procedural history of like, which lower courts it went to, if it even did. But the entry point is basically in terms of the court is grappling with, yes, it's grappling with treaties, but it's really grappling with what's known as customary international law. It's not citing precedent U.S. Supreme Court cases or U.S. federal cases. It's talking about treaties, but it's not citing them or interpreting them. It's talking about throughout the case, again, this like, all of us agree that the doctrine of conquest, the doctrine of discovery, this is something that all nations, and again, it's a caveat, all Western nations at the time agree on. And so this is this area of law that we won't talk about again in this class, and it's a fairly unusual area of law that you wouldn't talk about probably in most of your first year classes. It comes up occasionally in international law classes, but even there it's somewhat rare, this international customary law. Like they're not citing any like concrete items of law, but it is this idea of this foreign relations and those types of things. Yes, it's about a property dispute, but really the way to resolve that property dispute is to think through all these big issues with regard to foreign relations. And so, just to kind of wrap up with this a little bit, so again, the ultimate decision is, one party owns the land, the other party doesn't, because both people can't own the land. And so I just want to step back from that, which seems very obviously, like both the plaintiff and the defendant can't own the land. I'm going to come back to, what was your name? Yeah.
Oh, Sharon.
Sharon. Why can't both seems like a dumb question, but why can't both the plaintiff and defendant own the land? Like, why can only one of their titles be like good legal title?
They brought up something about absolutism.
Uh-huh. Uh-huh.
But just the idea, that's just impossible.
So yeah, it feels like self-circular, but like, why is it impossible? Like, what would happen if both of them owned the land and both of them were given?
No one really owns it then.
And what do you mean by that? I think you're right.
No one can exercise control.
Yeah, because
They both have title to it. It feels really circular.
Yeah, but it's this idea, if both of you own the land, then in a way, none of you own the land, because like all the things that we say an owner can do, and again, we'll talk more about this next class, but we've already hinted at some of them, like the right to sell, the right to convey, the right to use, all those things we say an owner can do. Well, if one of you is doing them and the other one doesn't want to be doing them, but we say that both of you have full ownership of the land, it like turns into this logical impossibility. And so the court refers to this concept of absolute title. It's saying like it has to decide who has absolute title. And we'll see as we get into later sets of material that there are occasionally times and specific cases with specific circumstances where courts actually do come up with creative solutions, and sometimes actually there is some wiggle room in that absolute title. And we'll see that as we get into the later set of materials, that title actually can be split amongst multiple people either at the same time or over time. Somebody could have legal title for X number of years, and then somebody else could have legal title, and we know that ahead of time that they're going to have it, and so they actually have some rights right now, even though they're not going to have possession for some amount of time. We obviously know like you can have co-ownership as a married couple or as friends who buy a house together, you can have co-ownership. And we'll get into a section of material about how you deal with disputes among even people who voluntarily agree to be co-owners. We know in mortgage law you can have foreclosure, and that can be some involuntary co-ownership at times, if maybe there's a split ownership and there's a foreclosure against one owner but not the other. But again, those are all kind of, not exceptions, but those are all caveats around this basic principle of absolute title, that if you are going to be found to have legal title to the property, like you and like maybe your group, like if you do have a group ownership situation, but like you are the only one, there can't be somebody else else who has absolute legal ownership. Because the things that we say owners can do it won't work logically that way. And so, again, that gets us back to I keep saying one last thing, but there's always one last thing in this case. One last thing with the case, if we think back to the Native American tribes, so the court says, no, that title was no good, this is the good title, this is the legal title, this is the binding title. At what point in this chain, I just want to make sure we're clear, or maybe not in this chain, at what point did the Native American title go away? That might be a trick question, but at what point did Native American title go away? Orange shirt and glasses, yes?
Maybe when England discovered the land.
Okay, so that's one possibility. Way back, like the discovery doctrine is what the court says it is. Way back then, at the time that the European discoverer comes, then the European nations all agree that extinguishes any title that previously was existing there. What about the court's comment that, I think has a comment that the discoverer is the one that has the exclusive right to buy or sell or it uses a few phrases, like to engage in negotiations with the conquered. What do you think that means? Like when England discovered it, did they engage in negotiations? Did they pay the Native Americans? I mean, we don't have this in the case, but I want you just to think about it.
No, they didn't, but those rules only apply to, they're basically saying that there's a second set of rules between civilized nations. Those don't apply when you're conquering land of people that don't know how to use it properly.
Yeah. So that France and England could have bought and sold from each other, like the Louisiana territory or whatever the conquered territories were, but that conquest itself of these non-Western groups. And the court isn't even really clear, if it extinguished title or if they never even had title to begin with. There's a little bit of a gray area there. It's unclear if the court is even acknowledging that the Native Americans, if none of this had ever happened, could the Native Americans have ever sold directly to somebody? Do you think, what do you think the court, if none of this had ever happened, and there were just some Native Americans, and then they sold directly to somebody down here in 1820 or whatever, what do you think this court how do you think the court would look at that transaction based on all of its discussion?
I feel like they may honor that because if they sold the land in the future, they probably would have been sort of forced to sell it. Like they said that when they sold the land, it really wasn't a fair sale. It was just it was a horrible deal for the Native Americans. So if it ended with the U.S. getting valuable land for very little money, they'd probably support that, I guess.
Oh, in a kind of a twisted way.
Yeah, they would honor that because the U.S. can buy this land for a very small amount of money.
Okay, and what if it had been Johnson or McIntosh buying directly for a small amount of money? Or whatever amount of money, just an individual engaged with the tribe directly. Like this, but with none of this having ever happened. It's kind of a weird hypothetical.
I don't know, I think part of me thinks that they wouldn't recognize it because they don't want to recognize the legitimacy of the Native American tribes. The other part of me thinks that they want to support anything that allows the white European settlers to take Native American land, so.
Yeah, no, and it's a very good kind of there's a tension there. And again, not thinking personally about this judge, but just the courts of this nation, those probably are some of the things, and this is the reasoning of the court in general, that probably is some of the things that would weigh on this court if that were the scenario that were posed. Because again, this court seems not to want to recognize, and it says customary international law doesn't recognize these kind of claims of Native American tribes, especially conquered ones. But it doesn't seem necessarily limited just to conquered ones, but saying especially if they're conquered ones. But it also seems to have this just pro-Western, U.S. Western nation settlement ideology. It talks about religion and savages and this languages that we wouldn't use today. And that seems to emphasize the second point you made. It just wants to get title into the hands of the civilized white farmers of European descent. Native American hands. So if maybe recognizing the legitimacy of that transaction would help that goal, maybe the court might do that. So there's kind of, you know, some tension in there as well. So again, we've already talked about a couple of these. We talked about the discovery rule, which is again this customary international law concept. This first-in-time principle that we mentioned, that the court mentions, we talked about how it's not necessarily, it is not a customary international law doctrine. It's tied to the discovery rule, but first-in-time principle is just a legal principle, even just a philosophical principle that we'll see come up several times throughout the semester. As a justification for ownership. Like if you're just sitting there in a philosophy class and you're like, how did I decide who is the owner of object A? One way that intuitively people come to is like, well, who was there first or who got it first? And so we'll see this come up, like as I said, not just in this case, but in many areas of property law, like this question of if we have to decide a dispute, one kind of baseline principle for helping us decide disputes is like, who was there first or who got it first. But we'll see that like philosophical principle isn't as clear as it seems, because like first to do what? As we saw in this case, if we were just talking about who was on this Illinois land that was at issue in this case first, objectively the Native American tribes were there first. But the court says, well, that's not really how we're using first in time with the discovery principle. For us, it was who was there to discover it first. It was a, you know, European nation discoverer from a civilized country in the western part of the world. And so it wasn't just about who was occupying it first. They said, you know, they had this more nuanced and somewhat troublesome definition of first. And so, and again, we see from this case that just possessing something, being there, having it, sometimes is a way that indicates ownership. It sometimes can be associated with ownership, but it doesn't automatically correlate with ownership. The Native American tribes possessed this land, but they were ultimately found not to be the legitimate owners. They couldn't convey title to later owners. And we'll see this again in other areas of law, that just possessing something doesn't always, sometimes it does, and intuitively we tend to think that possession means you own it, but we'll see that it doesn't always automatically connect to ownership. Okay. This is just a summary of everything we've said. So I think, did I assign the note on Locke's labor theory, or is that next class? Anybody, who remember reading a note on Locke's labor theory? All right, so we assigned it. So since you raised your hand in the front row, tell me your name.
Olivia.
Okay, so since we didn't bring that up directly during the case, I want to talk about why it was assigned with this case. Like, what is it at first? Like, what is?
It's the idea that we have natural rights to our own bodies, and by default have right to our own labor. So if you take something from the common ground, the example used was like picking an apple. That apple because you expanded your own labor, which you no longer to possess it.
Yeah, so again, this is a philosophical theory that is sometimes turned to as part of like property law and trying to come up with like answers about like who owns something. Well, one way that you can kind of look at property law, as we said, kind of work through like, well, who was first to do the thing that we think matters first. Another way that you can kind of work through some of the problems with property law is to apply this concept of labor theory. Like, who put their work, their labor of their body and mind into this tangible thing, or sometimes intangible thing, and maybe that's how we should award property ownership. And so if you were thinking about applying Locke's labor theory, as I say, it's like one of the bullet points in the case, even though we didn't directly talk about, like, how does that tie into the case? Like, how might you argue like this result was justified in a way by Locke's labor theory?
Well, they talked about how the Europeans were cultivating the land, engaging with it, versus the Native Americans that were more nomadic. So they could use Locke's labor theory to say, oh, well, the Europeans, they put their labor into the land by cultivating it, building houses, whatever, versus the Native Americans that had a more
one of the justifications for why, the Native Americans, even though they were the first to possess the land, they weren't the first to do the things that we being the court at that time, require for ownership of the land. One of those things might be all of the description you just gave, and can tie in the labor theory. As well as just the discovery and the labor that the European nations put into the discovery. The court doesn't go into that as much, but obviously a lot of labor was involved there in like the discovery of these Western, supposedly undiscovered lands. And then we talked again during the keynote moments about the just the cultural context that this case was decided in. And so I think that's all I want to say on things. Let's make sure. Yeah, for now. So I think that's all I want to say on the Johnson case. So before we kind of turn to the next set of materials, questions, lingering questions about. All right, so again, all of this first couple days set of materials is under the general heading of like first possession. How does somebody first become an owner of something, and what does ownership even mean? And so we've talked a couple times about already, we'll talk more about ownership as a bundle of sticks. And so again, non-lawyers tend to just think like, oh, I own something, I can do whatever I want with it. Whereas lawyers and property theorists, they have a more nuanced, kind of detailed concept of what ownership means. And again, it's associated with this famous professor who came up with this analogy, like it's a bundle of sticks, meaning there are certain rights and responsibilities associated with ownership. And that with regard to the very same piece of property, whether it's a piece of land, whether it's an apartment, whether it's a computer, different people may hold different rights with respect to that property. We saw, in this case, the court says, in theory, the Native Americans could have the right to possess after they've been conquered, so ownership was in the conqueror, but the conqueror could have benevolently let the Native Americans have the right to possess, or they could have said, no, and we're going to kick you out, we conquered you. But that would have been like a moment when, two different people groups have some rights with respect to the same property, but ownership was still in the one group, the conqueror, that side of the chain of title. Some of the rights, and we'll go through these as we go through the semester, but we've already talked about some of the rights in the bundle of sticks, and so they're fairly obvious when we're talking about the backpack, and you can get a little more detailed with that, but these are the types of sticks in the bundle. And again, as we'll go through the semester, we'll talk about how the sticks are not like just one size fits all with regard to all property. We'll see how this is like, again, it's just an analogy, it's just like a metaphor, but it's a helpful metaphor if you're trying to think about, oh, why with regard to like certain types of intellectual property do we let people have maybe licenses on demand with certain types of patents? Or why with regard to apartments do we allow landlords in some states to like absolutely set the rent for commercial apartments, but that they're constrained by state laws with regard to how much they can raise the rent for residential apartments? Like why is there a right to charge X limited in some cases and not limited in other cases? So again, we will come back to this analogy much, but for now, in the last 10 minutes of class, we won't finish the whole case, but last 10 minutes of class, let us talk about boxes and get into this one. So, who's about, yes, name? Brandon. Brandon? Okay. All right, so just tell us, it's pretty straightforward facts. Tell us about the two parties and the situation that came up here.
Most of the plaintiff, he was hunting a fox with some hounds, and Pierce saw him hunting or chasing the fox, shot the fox with his gun, picked up the fox. Post sued because he wants the fox.
Good, so good basic facts. Where did this all occur?
in New England.
Yeah, but I want to be a little more specific, like on Pearson's land, on Post's land, on somebody else's land,
Public property.
on where?
Public property.
Public property, yeah, so it occurred on a commons apparently, or what was treated as a common. So it wasn't either of the parties' property, and it wasn't some other private individual's property, it was some like open area that was open to the public. And again, we'll talk next class a little more about how when things don't happen on commons, that there's different rules, but the rules are kind of, we're just stepping out here that like this was nobody's land, so the item of tangible property, the fox, was like just a unowned fox on unowned or publicly owned land. So we all own this land, maybe it was the local town council's park or something. All right, so what is the very first line says this is an action for trespass. Since it was public land, why are we talking about trespass?
Because it's who owns the fox.
Uh-huh.
The fox.
Good, so it's about so this is again, like the old civil procedure terminology can be a little odd sometimes. This is about trespass on personal property, the fox being an object of personal property. And again, you'll see this terminology, I think it was mentioned in one of the notes, but property as a generic term just refers to all property. Real property is the phrase used to refer to like land and buildings on land. Personal property is the phrase used to refer to like things, so anything that's not land. And then intellectual property, we'll get to in a couple classes, but that's its own category. And sometimes personal property is called chattels. It's a funny French word, but so you'll see that occasionally in the notes. Sometimes personal property is called chattels. Okay, so we're back to this case. So tell us about what because this got all the way to this is that weird kid one. So this is at the Supreme Court of New York, which in New York, it's weird, I think. The Supreme Court is not the highest court in New York, right? Didn't you learn that in some class? Yeah. So it's not actually the highest court in the state, but I think it is an appellate court at this point. So it has gone through, it did go through a trial, right? Who won at the lower court?
Plan.
Yeah, lower court. Post, yeah. So Post is, Post, because they're both P's, it's confusing. Post won, but Pearson is upset with that result and he appeals because he wants to win. Okay, good. So, what is kind of this court's starting point for like how it decides who is the owner of a fox that is hunted?
It goes into how wild animals are owned in theory.
Yeah, how are wild animals owned in theory? What does it tell us the majority?
It goes through a lot of different philosophical reasoning. About if it's wounded or if it's if you prevent it from fleeing, like if you ensnare it. Any way like that, that's how you does it.
So if we go back to, because the court seems to be trying to grapple with like a specific application of like, who owns it? Who was the first to do like X with it? And so what does the majority think? Again, it goes through some competing views in the learned theories that it cites, but ultimately, what does the majority think that you have to be the first to do to be an owner of an object like a fox?
To wound it or trap it.
Yeah, and to wound it, how? Yeah, so just like, a little like dabble, like a little brush on its tail, that's not going to be enough. After going through its learned theories, it says you have to be the first to ensnare, like trap it or mortally wound it. And as you point out, we won't make you go through in class, it goes through all of these ancient learned theorists, which sound like Harry Potter characters, but they are all actual real theorists from like Rome and from British times. And so, again, it doesn't have, does it cite cases? No. So, and again, you take in your LSS classes, the courts are looking looking for something, some legal reasoning to support it, and so it didn't have precedent cases to cite or didn't choose to cite any. So it cites, policy, and it cites other secondary sources from, other jurisdictions, obviously, that it thinks help support this rule that it ultimately emerges with regard to the first in time. So the majority cites all those cases, and those seem to support it. But the majority also seem to have some practical reasons for thinking that its rule about who owns the fox was the best rule. Like, what practical result will occur with regard to foxes from the majority's rule, according to the majority?
There would be a lot of cases where people would say, well, no, I was chasing it first, or I was chasing it first.
And why would that be not a great thing according to the majority?
It would overwhelm the courts with frivolous cases.
Yeah, so there'd be all these fact-intensive cases about foxes coming to the courts because the rule, if the majority's rule were not adopted, if we had a rule that, we'll talk about the dissent next class, but if we had a rule more like what the dissent would recommend, it's not as firm as the majority's rule, we'd open the door to the floodgate of, again, cases about foxes, which sometimes opening the door to the floodgate of cases is important. We think for policy reasons, we want to make sure that we are able to have cases about custody of children. Like you want to have, if that means a floodgate of cases, that's an important thing. Foxes, maybe not as important as deciding custody between two parents. Foxes, who owns the fox? We want to have a rule that avoids a floodgate of cases into the courthouse. And so the majority thinks that its rule provides greater certainty. It is a more black and white rule. Okay, last question for you. What else would the majority's rule do in terms of at the time of this case, were foxes liked by society? No, what were they considered? Yeah, pests. And so the societal goal in terms of, separate from not overwhelming courts, but just in terms of foxes and number of foxes, what is the goal of society at this time?
To decrease the number of foxes.
Decrease the number of foxes. So what would be the argument that the majority's rule does that? Or doesn't?
I guess so that hunters would be encouraged to wait for snared animals. That's it.
Yeah, so that hunters would know, just putting in effort is not going to get you ownership, and so you are going to have to invest in fast horses, fast dogs, bigger guns, because that's the only way you will win the fox, is to do the thing that we have said. You have to mortally wound it or actually trap it. If you do anything less than that, you're not going to win the fox. And so communicating this rule to kind of society once the decision is made, one argument from the majority would be, well, this will encourage more efficient fox hunting, because now all the hunters know that they have to be more efficient. There's a counter argument to that the dissent talks about, but we will pick up with the dissent tomorrow. So again, we did not quite finish, so refresh your memory. We'll start with the dissent on this case tomorrow.
feel that way. Where are you from? We're gonna went after that. I think I'm not that idea. I only brought one. What? Dude, we got Friday, Thursday. Do you have Alex today? And there's that guy out of the road. That's sad. Yeah, it's right there. I'm taking the library. Okay. I jumped in at 1. And I have to run my car to get my student. Alright, so I can go scan right now and I'll talk to you. Are you good to go? Alright, thanks. No problem. We're good, man. Mr. Gifford. That's what we got. Fucked up with that cap, man. All the professors like, hey, cap guy, hey, cap guy. Oh, it's house handed. It's house handed. Pretty sure. Alright.
It's the disruption.
Yeah.
Hey, look at that.
I mean, I don't know if it's that
Sweet.
Well, no, it's good. You're like, what? I'm so over this. It's on my brain. Feeling it.
Okay.
Yeah, and we're gonna talk more about labor theory and how it works. Because sometimes we like, what if I understand why?
You stop right at the stop
I'm actually making
you tell them,
less
you know what,
so we
you
can
go
want to
first.
reward that. Or
Yeah,
make
that's fair,
sense.
that's fair.
Maybe you
I'll follow you in the dark.
in the way that they were like taking care of it, worshiping it. That was three different. Yeah, yeah. So we're gonna talk more about labor theory. So bring that up when we talk about it. Yeah.
So I was thinking about if you only had the chain and how we view it. We kind of viewed it as, yes, we want it